Hello and welcome to Talking Points. I'm Dave Kelly, Director of Advanced Media Production at Cal State Long Beach. Today we're going to talk about constitutional issues in the United States and how those issues are often decided by the Supreme Court. My guest today is Dr. Kevin Johnson. Dr. Johnson is the Director of the Center for First Amendment Studies. Welcome, Kevin, and thank you for joining us on Talking Points.
Thank you for having me.
Well, let's start the conversation by engaging in a little bit of Civics 101, very briefly. Okay. Our Constitution was ratified around 1787. We've been a constitutionally governed society since then. We know that in the Constitution there were three branches of government set up. The executive branch, which is headed by the president. Executive branch is supposed to faithfully execute the laws and carry out the laws faithfully. Legislative branch passes the laws and also raises the budget. Of course, that's the House and the Senate. And then the third branch is the judicial branch, which is headed by the Supreme Court, and they ultimately determine whether the laws passed by the legislature pass constitutional muster, and they also determine whether the executive branch is carrying out those laws faithfully and appropriately under the provisions of the Constitution. So having said that mouthful, we can get started.
That's right.
With where we are today in our political landscape. We know that many issues today end up in political gridlock. And when that happens, the Supreme Court is often called in to do most of the heavy lifting to determine a way forward. And when that happens, usually the losing side of any given case will at times accuse judicial activism on the part of the court.
That's right.
And so what is judicial activism, and what are some recent cases where that accusation has been raised by the losing side?
Well, usually judicial activism is raised when the American public believes that the court is ruling against the will of the democratic consensus. So what the people want is not necessarily what they get when the Supreme Court interprets it. And so the Supreme Court then is, in the words of people who are opposed to judicial activism, they would say that they're legislating from the bench, that they're making a decision that impacts American people without really having a whole lot of say in the democratic process, which is what the people would be electing in terms of the House of Representatives, the Senate, and the President to determine that legislation. And so judicial activism is usually the catch term that people use when they think that the justices are acting on their own and not on the will of the people.
And another one of those phrases that we hear is judicial overreach, for example. Some recent cases where these allegations have been raised.
Well, so for example, in the recent same-sex marriage case, I think a lot of people were upset with the decision of the Supreme Court in allowing the constitutional protection for same-sex marriage because they felt like the Supreme Court wasn't upholding the Defense of Marriage Act and the other same-sex marriage pieces of legislation that were voted in by the people. And so these types of legislation that are voted in by the people, when the Supreme Court acts on them and says, yeah, I know that the democratic consensus wants them, but you don't get to have them, that's when we are charging of judicial activism.
There was another case back in 2000 involving the election between George W. Bush and Al Gore. That ended up in the Supreme Court in a case known as Bush v. Gore. What about that one?
So that decision was one of the biggest controversies in American history. It had to do with deciding the fate of the presidential election and overturning the Florida Supreme Court ruling in that particular case. The result, of course, was that George W. Bush won the presidential election. And so that was one where the people were on one side saying, let's allow for a recount, let's make sure that all the votes are counted, let's not allow the courts to intervene in this, and then whatever the decision is, that's who the next president will be. And so there were charges of judicial activism on that side that said that the Supreme Court should probably not get involved in those elections, and that may have come into the favor of Al Gore winning the presidency. And so that was a big case when it comes to the court intervening in democratic politics.
And there are a couple other cases that we're going to get into in some detail in a few minutes. One of those is Citizen United. That's where the folks on the left side of the spectrum feel that there was judicial overreach or activism on the part of the conservative-dominated Supreme Court, and also the Hobby Lobby case, where there was a decision that did not sit well with the liberal side of the court. So we'll talk about those in just a moment. But first, let's talk about why there is this supposed split in the Supreme Court between the progressive or liberal side and the conservative side. And there really are two different kinds of interpretations of what the Constitution is supposed to be about for this country. On the conservative side, and this was a point of view that was promoted most strongly by the late Justice Antonin Scalia, and that was the idea of the original intent of the framers, or originalism. And this philosophy basically says that when the founders wrote the Constitution, they meant what they meant, they wrote what they wrote, and we should adhere to what they meant and what their original intent was. That's originalism. On the other side, the more liberal side of interpretation, folks call the Constitution a living, breathing document which guides our hand, but also allows for sort of an organic interpretation of what we should do, especially in those areas where the founders could not have foreseen the future. So talk about that split and how that has been sort of a motivating factor in these charges of judicial activism one way or the other.
Well, but before we do that, I kind of want to dispel the myth that it's so ideological in terms of the way that we think about the Supreme Court. So we usually think about the Supreme Court as this divided 5-4 kind of branch, but if you take a look at the history of the decisions, there's only been about 10 to 15 votes per session where it's come down in 5-4 ideological splits out of the 75, 80 or so cases that they hear in a given year. And so you're not really talking about a lot of the cases being decided in the 5-4 way. In addition to that, you've got a lot of cases where even within these splits of the ideology, you've got this idea of the justices differing even within those ideologies. So for example, in the case of Brown versus Entertainment Merchants Association, which had to do with whether or not video game manufacturers could sell violent video games to minors, Justice Scalia and Justice Thomas both considered conservative justices, both deciding in similar ways on a lot of these 5-4 cases. What they decided in that case were very different ends of the spectrum, using the similar rationale, but to support two different causes. And so I think that the split between living constitution and a strict constructionist is a little bit at odds. But let me explain what that means real quick for you. The living Constitution is the philosophy that we need to interpret the Constitution in order for it to work for us today. That the constitutional document was ratified originally, and that what was built into there were certain values that need to be extended into current situations. Just as America matures, we should be able to figure out how that document means for our given circumstances, because we're the ones who have to live with it. The strict constructionist or the historical interpretationist would say that we need to take a look at the document of what it meant at the time and look at what the words in the Constitution are and apply that standard to today. So it's a different way of thinking about judicial opinions.
So a lot of the cases do not come down in a 5-4 split, as you mentioned. It's the high-profile ones that get all of the attention, and
That's
those
right.
usually just a handful of the large number of cases that we hear about for those purposes.
Yeah, the most common decision by the court is a unanimous opinion. That's one thing that most people don't understand. The Supreme Court comes down with the most common opinion by the Supreme Court is not just a majority, but it's a unanimous opinion. That's the most common split.
And that is, as you say, that's something that people are not that familiar with because we always hear the sound bites and
That's right.
and in the media they play up this conflict.
Right, and you like the conflict, and you like the idea that there's an ideological divide, and those are really heated issues. I mean, when you talk about those cases like Citizens United, Burwell versus Hobby Lobby, those are really divisive cases in American opinion.
Well, let's get started on talking about Citizens United. What was the essential outcome of the Citizens United ruling, and why does it have people on the other side of the aisle upset?
Well, essentially, Citizens United allows unlimited amounts of campaign expenditures to be used by unions and by corporations. And so it's created a lot of backlash, because now a lot of people are not very happy that those with less money might have less influence or less say in the political process. Those who are in favor of the decision say, look, and we have this constitutional right to freedom of speech, and that doesn't matter how much money you have or how little money you have. In America, we should be able to do with our money what we want. And so that's the fundamental conflict. How do you balance the freedom of speech for all, and does money crowd out certain types of speech?
Well, Justice Kennedy, who is one of the conservatives, but who has been seen recently as the swing vote, actually, on the court, he wrote the decision in January of 2010. Let me read just a couple of lines from Citizen United. Justice Kennedy writes, "Political speech is indispensable to decision-making in a democracy, and this is no less true because the speech comes from a corporation." If I go to the next page, he continues, and at this point says, "All speakers, including individuals in the media, use money amassed from the economic marketplace to fund their speech, and the First Amendment protects the resulting speech. Under the previous rationale, Congress could also ban political speech of media corporations. Although currently exempt, they accumulate wealth from the help of their corporate form, may have aggregations of wealth, and may express views having little or no correlation to the public support for those views. Differential treatment of media corporations and other corporations cannot be squared with the First Amendment." What about that?
So what Justice Kennedy is essentially arguing there, which is different than a lot of the arguments you hear in the popular controversy about Citizens United, is he's specifically referencing the freedom of press, right? I mean, that the fact that these media organizations are structured in terms of corporations today would mean that you might be in the business of not allowing money to be spent on publishing editorials, right? If you want to run an editorial and you're a Fox News Corporation or a Los Angeles Times or other news outlet that is corporately structured, that you might not be able to spend your money on those editorials to be able to speak about particular candidates in election cycles. And so Justice Kennedy views that as a particular threat to democracy, and so he wrote that in the opinion.
Okay, and with that, we're going to go to the break, and when we come back from the break, we'll explore Citizens United a bit more. We're going to talk about some other controversial cases, and we'll continue this conversation. Stay with us. We will be back. We'll talk more about the Supreme Court and get into these cases in greater detail. Stay tuned.
Do you love to travel? Understanding the world and all of its diverse cultures? Ever thought about becoming a foreign service officer? Living in another country and helping to promote a positive image of America? Or going undercover and working for the CIA? Or as a lobbyist, representing different interest groups to members of Congress? You can become a part of this exciting field with a degree from Cal State Long Beach.
Welcome back to Talking Points. I'm Dave Kelly, and my guest today is Dr. Kevin Johnson. We're talking today about the Constitution and how many issues are decided by the Supreme Court. Kevin, when we left, we were talking about Citizen United, one of the most controversial and one of the most talked about decisions by the Supreme Court in recent years. It was decided in January of 2010. I have an article here that was written by George Will, a syndicated columnist. He's a conservative. He supports Citizen United. So I'm going to read a little bit about what he said, and also with some comments by Elizabeth Warren, who's a progressive liberal Democrat from Massachusetts. She's has a different opinion, and so we'll try to square those, and then I'll give you a chance to comment. So let me just start with what George Will wrote about Citizen United. He said, "The decision simply recognized that Americans do not forfeit their First Amendment rights when they come together in incorporated entities to magnify their voices by speaking collectively." He goes on to say that William Blackstone, the English jurist who richly influenced America's founders, said corporations are artificial persons created to encourage socially useful cooperation among individuals and are accorded certain rights so that they can hold property and have lives, identities, and missions that span multiple generations. Now, Elizabeth Warren, on the other hand, says corporations are not people. And she adds that people have hearts. they have kids, they have jobs, they get sick, they cry, they dance, they live, they love, and they die. To which George Will responds, he says, a bit sardonically, he says, and a few teach at Harvard Law School, as Elizabeth Warren was able to do, only because Harvard did not die. It is descended from the first corporation chartered in colonial America. So what about that exchange?
Okay, so I think that this posits a difference in the court. So I think that what Elizabeth Warren here is talking about is how do you textually define a person in the Constitution that have rights? And I think that this is echoed by Justice Ginsburg in the oral arguments where she says, corporations aren't exactly persons. They weren't endowed their rights by their creator, for example. And so they had this little exchange about what kind of person the corporation is. There was a fundamental exchange in the decision between Justice Scalia and Justice Stevens on this very question. Justice Scalia argued that people got together in colonial times and that they were able to share their opinions on things, that the Quaker Corporation, for example, was able to distribute pamphlets during that era to be able to spread their messages. And so the corporation today should be able to do the same thing when it comes to elections. Justice Stevens took a different track when it comes to interpreting the Constitution historically. His argument was that corporations are not just collections of persons, they're special types of persons. And when a corporation is issued its charter by Congress in the colonial era, where there's only about 300 original corporations where those charters were granted, Justice Stevens' argument was that those corporations were supposed to answer to the Congress to further the specific objective of the country, right, of what the Congress had dictated. In other words, Justice Stevens' argument to this originalist idea that you have a corporation gathered to express their rights, Justice Stevens says, no, they were gathered for a specific purpose, and that purpose was authorized by Congress. The corporations answered to Congress, and the most important point I think that is made that really isn't addressed anywhere else in the Citizens United decision is when Justice Stevens is basically alluding to the idea that corporations answer to Congress. They don't get to choose and have a say in who they answer to. And so that was the dissenting opinion. And so when you're arguing about the role of the corporation with Harvard University and so forth, I think that Justice Stevens, Ford appointee, so a Republican justice, I think that Justice Stevens would disagree with that. I think that he would say that Harvard University was established for a specific purpose. It was an educational purpose, and that educational purpose then answers to the question of whether that educational interest is advanced by Harvard University, and that's for Congress to decide. And so should Harvard University have a say in advocating for a particular candidate in an election? I think that even Justice Stevens would say that's beyond the scope and power of a corporation.
What about this argument that some folks have made that corporations are a very important part of our society today? They have also evolved to become some of the most important players in the economy. They provide jobs, they provide pensions, they provide philanthropic donations. They're involved in the civic life of many communities, and if they were to go away or to be regulated out of existence, there goes the community, essentially. And so people that make that argument say, well, if a corporation is going to be most affected by a politician's regulation and taxing strategy, why shouldn't those corporations have the opportunity to have a voice in terms of the election campaign?
Yeah, I mean, I think that in many ways, what Elizabeth Warren would say is that they do have a voice. They can speak their minds about how the legislative process affects them. They can talk about how legislation is detrimental to their business practices. They can talk about the effects of that regulation. They can talk about what kinds of things they need in the economy. The line, I think, for somebody like Elizabeth Warren and for Justice Stevens is to say that you don't necessarily get to advocate for a candidate in an election to decide who you're answering to, right? That's the line, because there's an appearance of corruption, quid pro corruption, and all of these issues come to play. But certainly the issue gets sticky when you're talking about media corporations, right? I mean, that's Justice Stevens' point. When you're talking about media corporations, there's a whole separate clause that's not about freedom of speech, it's about freedom of press, right? And when the media organization is structured as a corporation, then things get really tricky, because that is their purpose.
And the conversation is going to continue about that case, I know, for a long time. Let's go to another case. This one involved a certain aspect of Obamacare, and this was the Hobby Lobby case. What happened in the Hobby Lobby case, and how did this deal with religious freedom?
Okay, so in the Hobby Lobby case, the Hobby Lobby and a couple other closely held private corporations, they were organized and as corporations. They didn't like the fact that they had to cover 20 types of contraception in the, as we call it, Obamacare, the Affordable Care Act. And so what they did was they sued, and they sued the Department of Health and Human Services because they felt like four of those types of contraception prevented the attachment of an already conceived egg, an embryo, to the uterine wall. And because it did that, it would constitute abortion. So they sued and it made its way to the Supreme Court.
Okay, and in regard to that case, again, we had the two sides of the court. Justice Ginsburg, responding from the liberal side of the court, said, the court's expansive notion of corporate personhood, and this ties back to Citizens United, I think, she wrote, it invites for-profit entities to seek religious-based exemptions from regulations they deem offensive to their faiths. Now, on the other side, Justice Samuel Alito, who wrote the opinion for Hobby Lobby, said, he emphasized the ruling's limited scope. For starters, he said the court ruled only that federal religious freedom law applied to quote-unquote closely held, as you mentioned, for-profit corporations run on religious principles. Even those corporations, he said, were unlikely to prevail if they objected to complying with other laws on religious grounds.
That's right.
So what do we make of all that?
So what the court ultimately held was that using the least restrictive means available test, which means that is there a way to meet the threshold of whatever is trying to be accomplished in the legislation without infringing on somebody's religious liberties? Is there a way of doing that? And what the Supreme Court ruled was that because there are 16 other options for women to use to work and plan their pregnancies, then they were able to preserve the religious freedoms of the corporation and still allow for family planning to take place. Now, on the other side, the argument was, why is it that the corporation has the right to choose for the women? The women should be able to choose on their own what is right for their health and their healthcare options between them and their physician. And if the Department of Health and Human Services says that 20 are within the range of acceptable possibilities, then the women in the corporation should have the right to choose.
All right, well, let's transition now to another ruling. You mentioned it earlier in the program, and that was the Supreme Court ruling on same-sex marriage. And the court ruled last June of 2015, I believe it was, that same-sex couples have protection under the 14th Amendment Equal Protection Clause. Explain what that clause means and how did the court exactly rule on this?
Well, what it means is that if a marriage occurs between a same-sex couple, it now has to be recognized in all the United States. And so you cannot discriminate on the basis of one type of marriage that is heterosexual and against another type of marriage that is between same-sex partners. And so now individuals have the freedom to marry whom they want.
And how does this relate to previous rulings or previous court issues in regard to marriage issues, such as, for example, mixed race marriage issues?
So The discrimination that is felt by gays, lesbians, bisexuals, transgendered in our country is very different than the discrimination that is faced by African Americans in the United States. So I want to be very clear about that. The rationale of the court is kind of tainted and stained with the same kinds of rationales that have been used. So for example, in the case of Loving versus Virginia, it involved the right of interracial couples to marry each other. The lower court decision in that case, the judge ruled that God created all races, black, yellow, brown, Malay, and placed them on separate continents, and therefore he never meant the races to mix. And so it was a religious rationale for preventing interracial couples from marrying. That stain of a religious rationale stuck with us into the same-sex marriage rulings, where to argue that same-sex couples should be denied the right to marry based on a religious rationale was one that didn't really sit well with the justices when it came to our enduring understanding of what it means to be equally protected in the Constitution. And so they granted the rights of same-sex couples to marry in the United States.
And there have been some cases, recent cases, where bakeries and florists who are run by devout Christians have refused to participate, and they have been taken to court, and there may be additional litigation in that area.
Right.
Unfortunately, we're out of time, and it's been a terrific conversation. It went way too fast, and hopefully we'll have you back again.
Thank you for having me. I look forward to it.
And thank you for joining us for this edition of Talking Points. Join us again soon for the next edition. Until then, I'm Dave Kelly. Have a nice day.